Доброго ранку, шановні.
Good morning, dear ladies and gentlemen. Greetings at Press Center of UCMC. Topic of the first briefing results of the roundtable in Parliament on the human rights agenda for Parliament. Alexander Matvichuk, chairman of the board of the Center for Civil Liberties, Alexander Pavlenko, executive director of the Ukrainian Helsinki Human Rights Union, Tatiana Pechonchik, chairman of the board of the Human Rights Center, Zmina. Good afternoon, dear colleagues. Thank you for being with us today. It is organized by the Platform of Human Rights Organization, Human Rights Agenda Platform. And in summer this year, parallel to campaign, it carried out a legal human rights campaign, 13 steps. This is plan of actions for the parliament concerning protection of human rights, and these are 13 steps in different areas, and human rights organizations believe that these steps should be implemented by the new parliament in the nearest future in order to change for the better the situation concerning protection of human rights. These are different areas. We had a meeting with, personal meetings with nearly all political parties who took part in elections, and we discussed with them whether these steps are reflected in their programs and how and what is their attitude towards these points. Now we may have these intermediary results, whether these steps are being implemented. And yesterday, together with 4 committees at Verkhovna Rada, we held a round table, and we had the agenda on human rights. We carried out fact check and how these steps are implemented. Now our task is here at this press conference to present the results of monitoring concerning this plan, and we would like to present it to the public. And now I give the floor to Alexander Pavlenko. Good afternoon. We are going back to those 13 steps that were proposed during electoral campaigns. The steps were provided to all parties, and now we would like to revise once again the content of each step and to analyze briefly what we want to reach. And to have changes at the level of Verkhovna Rada. So the first step, these are the changes to Constitution concerning Part 2 of the Constitution of Ukraine concerning universal freedoms and rights of people and citizens. A commission was created on constitutional reform, and they worked on materials. This work was not completed, and it is really urgent as of today. From the times of the adoption of Constitution that happened in 1996, we have significant changes in geopolitical promotion of Ukraine. We see that Ukraine has clear vector in its movement to the European Union, to the standards that work at the level of the European Union, and those norms that were adopted at the legislative level, at the level of the Charter of the European Union, they do not now properly correlate with the formulation and the scope of those rights and freedoms that are fixed today in the second part of our Constitution. Respectively, we have proper motives why we see the need in such a step, and this task cannot be resolved quickly. This should be thoroughly thought through work of a Constitutional Commission and the Parliament to discuss all the provisions that should be proposed and then considered and approved in the framework of this constitutional process. Second point, I would like to stress that there should be important point. This is for the parliament. There is an unresolved issue concerning selling of agricultural lands. And due to the decision of the European Court on Human Rights, strategic directions should be established and some obstacles should be overcome at the level of legislation and at the level of implementation. One of the points we mentioned today is the situation concerning approval of the decision. It was taken in 2018, candidature against Ukraine, and the European Court recognized that existence of such a moratorium constitutes violation of the right for freedom to own this land, and Ukraine should take steps at the legislative level in order to break this monopoly. And this is not a simple process. Not just lifting the moratorium, there should be proper policy, how these issues should be regulated, how to own land, without harm, without excessive utilization of this land. There are many practices that exist in the world that can be also implemented here. Also, it should go in parallel with the process of lifting the moratorium on sale of land, but it should not harm the cultivation of land. This is a complicated process, so there should be proper legislation and proper mechanism should be developed for this. Now I give the floor to speak about other points. I give the floor to Tatiana Pichonchuk. Good afternoon, dear colleagues. I would like to speak about 4 points from this list, and I'm going to tell you about whether we have progress in implementation of each of the points. One of the points is about discrimination in Ukraine. Changes should be introduced to administrative and criminal codes to improve the mechanisms of bringing to responsibility for discrimination and crimes based on hatred. And here we have some decision that resolves this problem. Draft law 0931, it was introduced in 2015 to the parliament. It went first reading in 2016, and from that time on it is still there, and it is in the new parliament now. And this draft law harmonizes Ukrainian basic law on the basics of prevention and counteraction to discrimination in Ukraine that was adopted in 2012. And this law harmonizes with the right of the European law, and additional types of discriminations are introduced. Multiple discrimination, victimization, association discrimination. This law identifies what is discrimination, what is not. Now, for example, positive actions. This law decriminalizes responsibility for discrimination. Now, for violation, criminal responsibility is envisaged, and this is excessive. And now this will be administrative responsibility. And we hope that this draft law will be adopted by Ukrainian parliament. And the other part of this program concerns hate crimes. And the Article 161 that should be corrected. Hate crimes. These are the extreme cases of discrimination when violence is committed against a person, and in our criminal code, they mentioned only some of the signs, for example, ethnicity, religion of the person, and there may be other designations, and we believe that they should be put clearly in our legislation. Second step, I would like to mention this is adoption of changes that would simplify registration of the place of residence in Ukraine, in order that each person be able to easily register its place of residence. And we carried out a survey together with our partners in Ukraine. It was revealed about 7 million people live in some other places, not at the place of the official registration. That's why they have problems in implementation of the rights, and our current registration of residents that was inherited from the Soviet Union. It was changed during tens of the years, but the key principle is the same. A person cannot be registered in a premise if the owner does not allow to do so, and often these permits are not provided. So we believe that registration should be of just of notification character, so just to notify about the registration and to have electoral rights at the place of actual residence. Also, efficiency is increased for the state. Local communities will know how many people they have, and they will be more efficient in distribution and planning of their budgets. And in this point, we have some progress. When the power changed, Volodymyr Zelensky and the Cabinet of Ministers of Ukraine, in several documents, they declared that there should be reform of the system of registration of the place of residence in Ukraine, and the principle should be changed. And the key method, the key body is Ministry of Internal Affairs. They should develop a comprehensive law, because the sphere, it also is connected with education, healthcare, and other sectors, and also recruitment to the army, subsidies, and electoral registers. So it touches upon many sectors, and we hope that such a draft law will be developed. And our organization prepared a survey, Green Book of Reform, and we hope that this comprehensive draft law will be developed and approved. Third point I would like to mention, this is regulation at the legislative level of the right status and guarantees of social protection for the persons who illegally detained by Russian occupation power in Crimea, in Donbass, and in the territory of the Russian Federation. This draft law that organizations that protect human rights, they have been speaking about it for a long time. We have many people who are in captivity and those who were released, but then unfortunately at the state level, we didn't have proper support that can be provided to these people by the state, and we have a big progress in Ukraine form. Now we have a presentation of the draft law that may solve this problem, and this draft law is from the Ministry of temporarily occupied territories, and together with Human Rights Protection Organization, this law envisages 3 categories of people who will be protected. These who were deprived of liberty because of political reasons in the territory of Crimea, Donbass, and the Russian Federation, and we believe this is about 87 people and civil hostages in Donbass. In the result of Russian aggression, they are in captivity, and we know about 120 such people and the prisoners of war who are still there. they are deprived of liberty, and we know about at least 28 people of this category. And this draft law, it envisages what state support may be provided to these people. This is yearly support for the period of imprisonment to their relatives, one-time pay for after release, healthcare service, compensation for legal help, and also assistance in employment, education for children, and many other types of support that is needed by the prisoners of Kremlin and their relatives. And we believe that Interdepartmental Committee will be created with the participation of different bodies and human rights protection organizations that deal with the issues of release of our political prisoners and other hostages of Kremlin, and a register will be created of such people. And what is also important is that this draft law will have a universal character, so it will cover not only those people who are now in prisons due to political persecutions or due to other reasons, but also it will cover those persons who were released. And in 5.5 years of Russian armed aggression, we have about 3,000 of such people. And last point I would like to say is the improvement of legislation about ombudsman at the Verkhovna Rada concerning human rights. We witnessed 1.5 years ago, the procedural violations, how Lyudmila Denisova was appointed. That's why human rights organizations and the coalition also initiates the introduction of changes to the basic law on the ombudsman in order to make this body more independent, more capable, more professional. And these changes, among other things, may include the removal of the conflict between two procedures of appointment of the ombudsman. For example, law on ombudsman envisages secret ballot, and in other law the ballot is open. Also, the law should clearly envisage the procedure of election of ombudsman in order that it adhered to Paris agreement of UNO to have consultations with human rights organizations, and there should be proper criteria for the person who will be nominated for this position. And also this position, it should become more transparent and more professional. I would like to present 4 next steps from our program of steps. I would like to start and say that Ukraine should show that it is ready to fight impunity, to ratify the Rome Statute, and also to ratify Istanbul Convention and to adopt the draft law on 0892. And Russian aggression brought many problems, and the state bodies cannot provide proper response for this if they do not introduce proper changes. And one of such changes is to implement international obligations that are included in Article 7, and the Rome State statute should be ratified in order that Ukraine become full-fledged member of this court. This ratification is needed also to Ukraine because international court now studies the materials at the preliminary stage, and it studies what happened in Crimea and what happened and what is going on now in Donbass, and the cases of Maidan are also considered. But Ukraine only has responsibilities and doesn't have any rights, and the certification of the Rome status provides the rights to invest, provides the rights to provide fair trial, and we hear many counter arguments concerning the Rome state. They said that, for example, Israel and US didn't ratify this document, and Ukraine shouldn't do this. But you should not think like this. But in US and in Israel, they do not have occupied territories, and in Ukraine, 5.5 million people live in occupied territory in Crimea and Donbass, I mean. And for these people who live under occupation, international justice and international criminal court is the only hope for justice. The opponents of ratification of the Rome statute, they say that this court is not efficient and it takes a lot of time and resources, but they do not mention the main. What can we do instead if this option is not ideal? Please mention any other agreement or structure Ukraine may refer to have at least a chance that Putin and his proxies will be brought to responsibility, criminal responsibility. There is no alternative, and the prospect of hybrid tribunal on Ukraine, this is difficult to create such a tribunal, nearly impossible. So the norm of law should correspond to the norm of life, and those military crimes and crimes against humanity that are committed, and even if International Criminal Court will start the main investigation, it focuses mainly on big fish, and those thousands of those who carried out these crimes with their own hands, they should be tried in the national system, and our bodies are not ready for this. In our criminal code, there is no such a notion about crimes against humanity. Tens of thousands of people become the victims of such crimes, but there is no responsibility for this. And the draft law that was created by our platform and the government that was voted in the first reading, its registration number 0892, it introduces this definition of crimes against humanity in our legislation, and is needed for thousands of people who were in captivity, who were tortured. This was really terrible period of their life, and it is invisible in Ukrainian society, and that we should become their voice, and we should force our deputies to pass this law on the whole. And one more important international document that is binding, that is the Istanbul Convention, that allows at institutional level to deal with the issues of domestic violence. This violence concerns a lot of people in Ukraine, women, men, children. This is a specific type of violence. It happens behind closed doors. If a person is attacked in the street, he or she may refer to law enforcement bodies, and society believe that it is necessary to prosecute such a person. But if a crime is committed at home, a person who is the victim of such a violence, it may be stigmatized because they speak about these topics, and law enforcers do not know properly how to deal with these issues, how to respond on these crimes, to these crimes. And a person stays together with the perpetrator, and everything continues. And the Istanbul Convention provides mechanisms to resolve the problem. And the Istanbul Convention should be ratified. It should provide justice and change the approach that we have in our society. And one more step that is envisaged by in our agenda is the reform of SBU, Security Service of Ukraine. Here, I would like to say that during 6 years, we heard from the leadership and from formal, informal and non-formal meetings with they say that in a warring country, no one reforms as special security services. But if we want to make change, we should reform security service in order that it implements its tasks properly at a proper level. So we attend round tables and we see that one of the threats is the supremacy of law, and this information at the round table was disseminated by the security service of Ukraine. So they just do not know what this rule of law is, and something should be done with it because they consider that the rule of law is a threat. So SBU, we should start reform of this organization. It should be deprived of inappropriate responsibilities. And also there should be proper public control over the activity of the special service, because we witnessed many cases when SBU was in the epicenter of international scandal concerning illegal detention of people for swap, and in the center of other scandals when SB officers used their inappropriate responsibilities to pressure business. Or 3 days ago, there was an information about SB officers who sold the opportunity of wiretapping to some people for money without public control over special security services. It is impossible to make improvements, even whether the country is at war or not. So also we should introduce the jury trial. In Article 124 of the Constitution, we have such information, and many people believe that jury trial exists in Ukraine, but I would like to tell you that what we call jury trial is not really a jury trial, because this is the model of a people's jury that we inherited from the Soviet Union, and in this the judge influences on the decision. And the main difference between people's jury and real jury, this is that it is independent of the decision of the judge. For example, in Germany, there are such trials. There is the rule of law and well-developed justice system and legal culture, but this is not the case in Ukraine. And we developed a draft law. It is now considered by the Ministry of Justice of Ukraine. At a round table yesterday said that it was sent for coordination to the central bodies of executive power, and we hope that it will be adopted, because it will change the process from inside of the system. You remember that, for example, prosecutor, he comes to courtroom, and he knows that the judge does not listen to him. Now, the prosecutor should have rhetoric abilities to convince the jury, and we will see that these Hollywood films will become our reality, and there will be competitiveness of the process, and also this will be good for society. For example, in US, people who were on the jury, they have a higher trust to judicial system, and this influences not only to the change of justice system, but also to the legal culture of society. I would like to say that in authoritarian Russia, they have imitation justice. Putin, starting December 2015, broadens these juries in the regions. Of course, in the cases concerning some crimes, and they provide such type of justice in some cases. And even Putin understands that this is needed. And about point 13, this is about institutional mechanism for continuous cooperation, independent of political situation, because four parliamentary committees supported us yesterday during the meeting, and we would like to see that these committees, we want them to continue this cooperation with us. So we need proper institutional mechanisms for this. And we will refer to the heads of each faction based on the results of this round table to meet with the responsible people's deputies, and we will inform the journalist public what factions responded and what factions demonstrated lack of interest in the topics of protection of human rights. I would like to continue, and I would like to speak about 2 points that are left. Olexiy said about judicial reform and its completion. And in this context, we also speak about executive service. It should be reformed, and one of the steps we should provide legal grounds for reform of penitentiary system in order that it provided protection of the rights of people who are deprived of their liberty. And during the last 2 years, legislation was developed concerning penitentiary system that was not passed through the parliament. It was not adopted. This work should be continued. So we are speaking about the reform of the penitentiary system in order it to be in line with real standards. And we had a meeting with the lawyers who work with cases of violence in 4 countries: France, Germany, Russia, and Ukraine. And we spoke with them. This was assessment of foreign diplomats and about 2 worlds. Incomparable level of problems. France and Germany, Russia and Ukraine. France and Germany, they looked much better than Russia and Ukraine. Of course, Ukraine looked a little bit better than Russia. So we have clear indicators what we should aspire to, and we should implement proper legislative changes. And the last point, this is transitional justice. During the last 2 years, legislation was developed and a proper model of legislation was developed. This concerns the law of the draft law on basics of state policy of protection of the rights of people in conditions of overcoming of consequences of the armed conflict. And now they work on the model within the commissions concerning legal reform, and also the issue of the ombudsman for human rights issue was discussed, and the model that should envisage overcoming of the results of the conflict, armed conflict. This is the issue of amnesty and compensation of harm that was done in the result of the armed aggression, and overcoming of the consequences, and identify the reasons, the issue of historic memory and creation of institutional stability, and prevention of such situations in the future. And this legislation should cover all these topics. So we presented our plan of actions, and we reminded these 13 steps that are included in it, and about the stages of implementation of each steps. And now we are open to questions. If you have questions, please ask. Raise your hands, dear guests. If you have questions, please. It is expected that in the circles of experts and public, we believe that these things should be done. We discussed these topics during many years, and we have big hopes. And yesterday, one of the participants of the round table, she said that the parliament should provide human rights protection result. And we work for this result together, and we hope that people's deputies will be able to demonstrate improvements concerning each step, and we will inform you in the future. And we see that the windows of opportunities, they may close, and what can be done during the first year in the work of the parliament, these things are much more difficult to do in the second and third year. And the office of the president, they identify their priorities, and we want to implement human rights protection agenda. And it also, and the people, society should have proper request from the power to implement human rights protection. And now we will be